Teenage District Court for County of Washington, is now back in session. Y'all will give days and the time.
You may be seated. Sorry. Is it Miss Lessel on the other side?
Yes. Oh.
Court does call the case of the People's State of Michigan versus Brandon Toma.
Good afternoon, Your Honor. On behalf of the people.
Deborah Schultz on behalf of the defendant, Mr. Brandon Thomas.
Brandon Toma, Your Honor.
All right. All right. My understanding is this is a waiver.
That is correct, Your Honor.
All right.
Your Honor, it will be a waiver on counts 1, 2, 3, and 4, and 7. The people will not be proceeding on counts 5 and count 6. Despite the way his convictions were entered on his lien, they were entered incorrectly. He is not, in fact, a convicted felon, and I was able to confirm that today.
All right. So 5 and 1, 2, 3, 4, and 7.
That is a true statement of our understanding, Your Honor.
And then at the appropriate time, the people wish to be heard on bond, please.
All right, Mr. Toma. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also, for the record, waive the writ.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, 4, and 7. 5 and 6 being dismissed. As to the circuit court arraignment, Ms. Lussell.
We waive the reading and ask that you enter not guilty plea on my client's behalf.
Defendant having waived formal reading. Pleading not guilty as to all counts. Court will enter that plea. Pretrial will be set for
November 8th at 1:30 p.m. with Judge Conlon.
November 8th, 2023, 1:30 before Judge Conlon. As to bound.
Thank you, Your Honor. Your Honor, at this time, the people are requesting one of two things: either that the court increase the defendant's bond to $50,000 cash surety, or that the court revoke the defendant's bond. First, when this case was entered into JIS, I don't know how this happened other than that count 7 is on page 2 of the information. It was only entered as counts 1 through 6. So count 7 was sworn to and open by MSP, but it looks like in JIS when the complaint then went, I'm making assumptions here on how count 7 didn't make it into JIS. Which then brings me to the arraignment. I believe the defendant was only arraigned on counts 1 through 6, which is, I'm hoping, why at the time of his arraignment, he was issued a $5,000 PR bond, despite that my office charged him with felonious assault and that my office filed a bond recommendation requesting $50,000 cash surety. In terms of me requesting the $50,000 cash surety, Your Honor can see the charges on the complaint. This is a situation where there was a domestic violence, or there was an argument in the house between two people that are in a relationship. I understand that likely included some domestic violence. However, that was not included in the police report for various reasons and has not been charged by my office. Nonetheless, the victim had to flee that house, get into her car, and drive away from the home through a neighborhood. The defendant jumped in his car behind her and drove erratically behind her. Now, he's also charged with OWI for that exact same driving. He had both alcohol and
Methamphetamine, marijuana.
Thank you, I apologize. He had alcohol, methamphetamine, and marijuana in his system during that driving. He is pursuing the victim. She's scared for her life, and he's driving erratically behind her. Ultimately, she's able to take a turn to get away from him. He ends up flipping his car. That's the basis for asking for an increase in bond to what it should have been set at, or what my office requested at the time at the time of filing these charges. In terms of revoking his bond, there has been additional information. This defendant was arraigned on June 14th, 2023. Now, because he was likely not initially arraigned on the felonious assault, there is not a no contact order in this file protecting Chris. As far as I'm aware from Lee. So I'm requesting the no contact order, that he cannot contact her in any way, shape, or form. In addition to that, Detective Swantek from Michigan State Police was able to get police reports from Wolverine Lake, which is the jurisdiction that the defendant now lives in, after his arraignment. So there are many reports from April 2023 until now, but I'm focusing on post-arraignment. After he was arraigned in July 2023, the defendant attempted to buy, I'm going to call them shrooms on the record. He attempted to buy shrooms through Facebook Marketplace, and he ultimately was ripped off, so he called the police to report that. In addition, on September 23rd, which I believe was just this last weekend, police were called out to his home for an argument between him and Miss Skinner. He blew a .19. Now, this is not contained in the police report. I believe there's contradictory information in the police report from the victim not being forthcoming with the police. I have since been informed by the victim, as well as her sister, that during that weekend, the victim and the defendant were engaged in an argument. The victim had to lock herself in the bathroom, and she held the door closed while the defendant was trying to break in the door using a machete. In addition to that, now this, I do not know whether this occurred before or after arraignment. I know that this occurred a couple of months ago is the language, but I don't know what that means in terms of before or after arraignment. The defendant pointed a gun to the victim's head. While we've been in court today, the defendant has been texting the victim about the situation, about being here to testify. The victim texts, and I have not shared this with Ms. Schlessel because I just got this since we've been present in your courtroom. The victim said, I can't sit there and lie when everyone knows the truth. All I can say is that you did not chase me down with a loaded weapon, but we both know that you did have a gun to my head. The defendant responded, the F word is the first word of the text. I know I effed up and I can't take it back, but that's not even why we are here, and you don't have to testify to that here. But then your family is going to take it out on you. I love you, but ask them if I leave you alone and we go separate ways and you just stay with them, if you can just not come. I love you and always will, but this is effed up. I've already been sentenced to 90 days with credit for 31 today for that night. I'm going to jail for it already. He's referring to, he was sentenced in Oakland County today for disorderly conduct. And he was sentenced to 90 days, but if he turns himself in tonight before 7 o'clock in Oakland, he would get 60 days is what I understand. For those reasons, the post-
Can I just stop you for a moment? I just want to make sure. The incident involving the machete occurred, we think, when?
September 23rd.
Okay.
The same night he blew the .19 with Wolverine Lake.
All right. And the gun to her head, we don't know when?
I just know a couple months ago, but I don't have a date on that.
Okay. Okay, thank you. Go ahead. I'm sorry, I didn't mean to interrupt.
No, thank you, Your Honor. That is why I'm requesting either that his bond be increased to the initial request made by my office, or frankly, that your office, or excuse me, that Your Honor revoke his bond. Thank you, Your Honor.
Response.
Your Honor, I would dispute that there was a machete involved in the recent event. And as far as the alleged gun event, it is my understanding, Your Honor, that that was prior to everything that was said. He was sentenced today, in Novi 52-1 District Court, and Judge Reeds told him that if he turns himself in before 7 p.m. this evening, that he would only do 60 days rather than 90. He has credit for 1 day. I'm asking, Your Honor, if you do have to increase anything. He was not under a no contact order, to my understanding, with the alleged victim in the Novi case. And she did want to have contact with him. And it's also my understanding that her family has pressured her to press these charges.
Can I just ask one thing? In the Novi case, is it Ms. Skinner?
Yes.
Okay, go ahead.
Your Honor,
Well, what was that charge?
Disturbing the peace.
yeah, he pleaded to disturbing the peace.
We got in a drunk.
Disorderly person.
From what? What was the original charge?
It was disorderly person, drunken, disorderly.
Your Honor, the original charge in the Novi case, disturbing the peace. And that's what he pleaded to.
Okay, all right, go ahead, Ms. Sussel, I'm sorry.
It's okay. Your Honor, I would ask, he has some issues with alcohol. He's going to be dealing with them when he's in Oakland County Jail and thereafter. I would respectfully request, because Judge Reed sentenced him to do certain things so that he does change his life. Your Honor, I would ask, if you have to do anything today, that at least you let him report to the Oakland County Jail first, so that he doesn't have to do an additional 30 days. That's what he was very worried about, is he's not going to be able to make it to Oakland County Jail on time. I would ask to change any of the terms, that you have them take effect at midnight tonight or in the morning at 12:01. Your Honor, I would ask for the mercy of the court. And Your Honor, he did show up to court today. He showed up to 2 different court dates this morning in Novi and here. And he waited here many hours, I would add, because this was scheduled for 9 a.m. And we got here from Novi at about 11, and he's been here since. So he hasn't left. He just went outside to smoke a cigarette. That's not the issue of showing up. And he doesn't even have a car. He took Uber here and paid a lot of money to get here, and was going to take Uber to the jail.
Oh. Have you been reporting to our community corrections?
Yes, I had, Your Honor. I had missed a few times away from this. Something weird said, I don't have my own vehicle, so there have been a couple of times where I could not fully get a ride or did not have money to take an Uber. But ever since I've been there, I have been testing positive for my THC, which you said I could because I have a medical marijuana card. But I have not tested positive for alcohol. The other night with the whole Wolverine Lake Police Department was the first time I had any alcohol in forever. It was a temporary lapse in my sobriety. I was probably clean for 3 months before that.
And Your Honor, he has been clean from methamphetamine for over a year. So he has been.
Well, anything you want to say about the text messages?
Your Honor, I'm kind of I know it's not by design, but I feel like a little bit ambushed here. And
You guys want to sit down and think about it?
Yeah.
I mean, there's not a whole lot there.
Your Honor.
I mean, I don't think it's an ambush. I mean,
Your Honor.
Your client's the one responding, so I mean.
Can I say something, Your Honor?
If you want.
Me to tell me that she was coming, and I know I shouldn't have said anything to her, but she was freaking out, and I love the woman, and I didn't want to see her pain, so I was just telling her, like, it's true, but I wasn't trying to threaten her not to testify or nothing. She texted me, and I know I shouldn't have responded, Your Honor. I'm sorry.
What was the part about not testifying?
He said, I know I asked that and I can't take it back, but that's not even why we are here, and you don't have to testify to that here. this is but then your family is going to take it out on you. I love you, but ask them, if I leave you alone and we go our separate ways and you just stay with them, if you can just not come.
Your Honor, I mean, I can't make excuses for that, but,
Oh, yeah, okay, good.
but
Glad you realized that.
But I will say that apparently, when we first got here, this victim or witness was not here. And we were going to bind this over. And suddenly she was here, and I'm told that somebody came to go get her while I was here in the exam and for a different case. And I'm told that her family threatened her and forced her to come. So that is what I think was the impetus for these text messages. I'm not saying they're excused for that reason, they're not, but I just wanted to give you some context.
Well, the last statement is clearly, I mean, I don't know how else to take it except as an attempt to not have her show up. You don't have to show up.
Can I turn my phone into the record, Your Honor? I have told her that if it saves her and my son and her relationship with her family, then come here, tell the truth, the whole truth, and nothing but the truth. I swear to God, I will turn my phone into the record today. I have not been
Turn your
turning.
phone into the record. I don't know what that means.
They were entering their text messages. I showed the whole thing, the whole conversation.
What's the whole conversation?
Your Honor, I think it's what he just said. I don't think we need to go further, but basically he told her if it helps things, then testify and tell the truth. Which is
Right, that's in that part, kind of, but then the other part, you don't have to testify to that today. He doesn't know what questions are going to be asked. And then you don't have to come.
Your Honor, I can't make excuses for that. All I would say is he's very anxious about making it in time before 7 p.m. at the Oakland County Jail because he doesn't want to do an additional 30 days on top of what he's already doing. And I think that he's a very anxious person. And I think it set his anxiety. He's got some anxiety and depression issues. And I think that has set those into overtime. And I just don't think he was being himself. Is all I can say, Your Honor. I can tell you that the anxiety has been there since this morning when we were in Novi. Because he was afraid he'd be jailed this morning and he wouldn't be able to come here and he'd miss his court date here. And then when he was here, he's afraid he's going to miss his jail time tonight.
Well, part of my problem is, and I don't know what happened at arraignment. I mean, I guess I could go look at it, but I probably don't want to see it. But one clear prohibition was there's not to be any use of alcohol.
Your Honor, that's true, and that's why he was sentenced to 90 days by Judge Reed. He violated that in his bond conditions there as well.
Well, hold on a second. From the September 23rd date or another date?
From the September 23rd date.
Oh, no.
Was a bond violation in his Novi case because of the 0.19.
And so when did the disturbing the peace or whatever happen? When is that alleged to have happened?
In May or June?
That's what we're here for. I think it was May.
Oh.
Because it's been a while out. We had to keep pushing it back. I don't remember.
Are you talking about the Novi disturbing the peace?
Yes, that's what I'm talking about.
I think
It's
that-
like, oh, wait, no, sorry, I have the wrong case.
No,
Sorry.
I think, Your Honor,
I think it was May.
yeah, I think it was May, Your Honor. I was not his attorney at the beginning of the case. I was only his attorney for the sentencing.
Looks like April 14th, 2023 is the offense date listed.
Of that one. I guess, so. This is, it's disturbing to me. Because at some point, So you're indicating that the machete wasn't part of it. Okay, fine.
That's not my understanding, and I was privy to a summary of it, and
Okay, that's fine. But his text messages acknowledge the gun to the head.
Your Honor, I think the gun was for this case.
No.
The gun in the other one was a different gun, and it was like this case that we're here for. A year and a half ago.
All right, so this case precedes the
Yeah.
Novi case, all right. It doesn't help me.
Yeah.
But the text messages that I'm hearing, he acknowledges the gun to the head because he's telling her she doesn't have to testify about
Well, but is he saying you don't have to say I put a gun to your head? Is that what it said? That's,
No, it's, as I understand it, it's saying, well, you don't have to talk about that today. That's how I understand.
well, Your Honor, I don't think he specifically says what to talk about and what not to talk about, and I would ask that you give him the benefit of the doubt.
I don't know how I give this individual the benefit of the doubt. It sounds to me like it's an individual whose life is absolutely, completely, and totally out of control. He's violated, although the bond conditions weren't full, he's violated the bond conditions regarding the use of alcohol. There is that issue regarding the gun to the head, which makes me also then, well, I understand you're making the representation counsel, which also then makes me seriously question the machete. Then the whole crux of this case is, and the felonious assault in this is him chasing her down with a car that he ultimately rolls. And I don't think, how I feel about it after hearing all of this, I don't think this defendant stops until she's killed. Then he stops. Go ahead, he can say what he wants to say.
I just want to say, as far as the chasing her down, I was never chasing her down. The trailer park that we used to live in, the exit is the same way she was going. And when she turned, I left that area. I turned right on the next street and was speeding out the exit when I flipped my car going over the bridge. I was trying to leave the area too, because I already knew she had called the cops. I was not chasing.
Oh, well, that's good. So the police are going to get called and you decide you want to leave.
Well, I was being accused of a lot of stuff, sir. I freaked out. I'm sorry. I have bad anxiety, as my lawyer said.
Hey, you want to say anything else before I'm finished?
Your Honor, I
You can
think.
say whatever you want. I mean,
I think we've addressed it to the best of our ability.
so as I was saying, I don't think with this defendant, this ends until she's dead. And then he has nothing else to chase, nothing else to sort of terrorize or do whatever. I don't think, and like I said, I don't even know what to do about this bond because I don't understand even under those, even without the last charge, I don't know why, I don't understand how this gets set this way. All right, so what I should do is I should just revoke your bond, which is really what I'm inclined to do at this point in time. However, I don't think, I mean, because this is going to go up before Judge Conlon, that revoking your bond really necessarily does anything at this point because he's going to ultimately set a bond in the case. But what I will do is I'm going to increase the defendant's bond. We'll be setting the amount of $75,000 cash as surety for the violations to date. And also the court is doing that because based upon what I've heard, the defendant poses a significant risk to the community as well as to Ms. Skinner.
Your Honor,
Particularly, yes.
can I ask that that take place at 12:01 or at 7:30 PM so that you can get to the Oakland County Jail?
Oh, not a chance. Go ahead. Did you want to say something besides? That's not going to happen. It's going to happen right now. If he doesn't get to Oakland County Jail, then that is not my worry. I'm going to be honest with you. I don't understand why this defendant is out at this moment. Bond is increased 75,000, cash surety. He doesn't, I have to give him another date for pretrial. I have to give him a name date. No, pretrial. Yes, ma'am.
So, October 11th.
So pretrial will be October 11th,
Is that at
2023
1:30?
at 1:30 before Judge Conlon. Defendant is remanded.
Your Honor,
Okay.
yes.
What? Yes, court is standing recess.